Good morning and good afternoon. I'd like to welcome you all to a LexisNexis complimentary webinar titled A Day in the Life of a Family Law Attorney. To litigate or mediate, that is the question. Before introducing our speakers, we have a few announcements. Today's program is not eligible for CLE credit. For our phone participants only, if a problem arises during the program, please dial *0 for the operator. We will be using the hashtag @LexisSmallLaw to have a conversation on Twitter during today's program if you are interested in joining us. The hashtag for this webinar is #Mediate, MEDIGATE. Please take note of the survey that is available to you today. We ask that you please complete it as it provides excellent feedback for us so we may continue to bring you outstanding programs that meet your needs. Our speakers welcome your questions. You can submit your questions via the Q&A section of the platform throughout our program today. We will try to address as many audience questions as possible, but please keep in mind that all questions may not be answered due to time constraints. No questions will be asked verbally. And now I'd like to introduce our speakers. Brad Micklin is the lead attorney and managing member at the Micklin Law Group. For more than 20 years, he has helped clients through some of the toughest, most emotional experiences of their lives, including high-conflict divorces, child custody battles, and probate litigation. Brad has extensive experience in the courtroom and has gained additional expertise and knowledge through advanced family law courses and training in handwriting analysis, body language, and advanced microexpression. In 2008, Rachel Alexander Esquire founded the Alexander Mediation Group to serve couples throughout the New Jersey and New York area facing separation or divorce. In 2011, she became the director of the Center for Mediation Solutions in Metuchen, New Jersey, and began an affiliation with the Center for Mediation and Training of New York, New York. Rachel is a court-appointed mediator on the New Jersey family and civil rosters. On behalf of LexisNexis, we thank Brad and Rachel for their time in preparing for today's webinar. Speakers, the floor is yours.
Thank you so much, Kathleen. I'm Rachel Alexander. I will be starting us off, and I want to welcome everyone. To begin with, I'm just going to run through a loose overview that we're going to try to follow today. I'm going to speak briefly about mediation and its benefits. Brad will speak about litigation and its benefits. We have a fact pattern for you that we're going to walk through and speak about some of the issues and how they might be best handled through mediation or how they might be best handled through litigation. So next slide, please. And the next slide. Some of the benefits of mediation, as I see them, and of course I practice, I would say 98% of my practice is mediation, so I'm pretty passionate about it. Mediation is wonderful in family law in particular. Family law is often described as the wild, wild west of law, and so the level of unpredictability combined with the sensitivity of the topics, it makes for a bad combination. I sometimes liken it to putting a family through a meat grinder. So the more we can keep families out of what can be a traumatic experience of going to court and losing control of things, not being the primary decision makers of their families and themselves, often we're being very protective of them in that way. We in mediation, we seek to facilitate settlement. We encourage discussion. We're allowed to think outside the box. We're allowed to speak freely until a decision is finalized. It's not set in stone, so people are really able to brainstorm and come up with resolutions together that they might not be able to come up with once we have the involvement of the court system and multiple attorneys. We really are focused on needs and interests of both parties rather than their positions, and not so much looking at what's right, what's wrong, who's entitled to this or that, but what does somebody need in order to proceed, in order to be the best parent, in order to be financially secure. It's a dialogue rather than just an advocacy for one or the other. As a mediator, I aim to really advocate for the family as a whole. It's a very cost-effective approach. It's not free. However, the parties can work largely, typically with one mediator, and then use their attorneys judiciously to review an agreement and as consultants. I mentioned the parties retaining control of the process. They also really retain a lot of control of the timing. Rather than having the pressure of being on a court calendar for a pre-settlement conference or anything else, they can really pace themselves and also maintain a lot of control of the timing of payments of things. So if they know they have limited funds, they maybe will schedule a mediation 3 weeks out to just kind of maintain, when their next paycheck comes in, they know they can put some aside for legal fees or whatnot. Mediation is protective of long-term relationships, whereas litigation and even the litigation process, or even if it never gets to trial, the whole litigation effort can really be destructive to relationships, not just between the parties, but between the parties and their children. And so mediation tends to be very protective of that, because mostly, especially when there are children involved, these people are going to need to be working with themselves for a long time in the future. Finally, I just want to say about mediation, we are able to really address legal and non-legal issues. Often they're issues of logistical things. How is my check going to come if I'm getting alimony? How are we going to handle such and such? That's often beyond the scope of what I will deal with if I'm just representing a client. But in mediation, we really work through those things so that we can have a post-divorce relationship and process running really smoothly. Next slide. Brad?
Okay. Hello, this is Brad Mick. I'm going to speak a little bit about the benefits of litigation. It may seem a little comical that I only have one thing listed on mine where Rachel had a laundry list of benefits, but essentially, at least at this introductory point, I want to explain that I'm here not to advance going to court and trial on things, but really to speak more about the litigation process and litigation track and how that may help certain issues where mediation may or may not be the best move. So the first thing that's listed here is that there's no attorney-client relationship with a mediator. A mediator, as Rachel indicated, is a neutral sort of third party that sits and facilitates the discussion. So the individuals that are in the process may not have somebody who's actually helping or assisting them in making their decisions or understanding their decisions. And it's sort of difficult, I would feel it's difficult when you're helping two people in a mediation to really advise somebody what's going to be best for them. So that's the major benefit that you get out of the litigation tracker process. And I think more globally, the litigation process, it forces certain issues to resolve itself or to move in ways that maybe mediation doesn't or doesn't always. Litigation has a lot of external factors that place on the issues or the individuals. There's a lot of cost, unfortunately, and obviously to litigation and having attorneys. There's often a lot of missed work, so their finances are affected. Sometimes there's parenting time issues because of the time it takes. So there's often a lot of external forces that will present themselves in the litigation track because you're forced to follow the court's schedule and the court's rules, as opposed to having the freedom to just do it whenever and however you want. And I think secondly, and probably most importantly, litigation gives a sort of finality to the process. It gives you a date certain by when something will be decided if the two parties or whomever don't resolve an issue beforehand. They know that not only will a person be making a decision at a certain point, but they know long before then when they need to do other things to have that decision made, when they have to go to court, when they have to retain experts, when they have to appear for depositions. It gets laid out in advance for them so they know at an early stage where that's actually going to be concluded. Whether or not it's how they want to conclude it, at least they will know that it will be concluded. Now next, Rachel's going to introduce a little bit about what makes an ideal client for mediation.
Great, thank you. So mediation clients often, these are ideal candidates, and this doesn't mean that people who have high conflict or all kinds of other things going on can't do mediation, but an ideal mediation client, there usually is some level of communication. Good communication between the parties is ideal, but having some awareness, some self-awareness, and also some sense of that communication even requires a skill set. And to have some self-awareness of what the where they fall in that, and a sensitivity towards how they are going to be able to communicate with one another. When there's shared concerns of any kind, and particularly when both parties are really can come together over the best interests of their children, even if they maybe don't agree on what the best interests of their children are, or they have disputes over that, when they're child-centered, that's helpful. There needs to be, mediation is an entirely voluntary process, so there really needs to be willingness on the sides of both parties. If I have one party who wants to mediate and another who doesn't, they need to get on the litigation track. Similarly, and I'll kind of kick this one to Brad, if I have someone where one party is deliberately or in a passive-aggressive way or just doesn't want the divorce, they're dragging their feet, it often forces the party who wants the divorce to go more of a litigation, to retain an attorney and go more of a litigation track just to get the fire lit and to start moving things forward, because they can really be trapped by waiting for more of a collaborative approach. And also when both parties have agreed that divorce is the next right step, that's helpful. It can be very difficult when one party really, as I was sort of speaking to just a moment ago, if one party really doesn't want the divorce, even if they're in mediation, there can be all kinds of ways that they're obfuscating the process, even unconsciously.
Now, turning to some of the litigation issues that make somebody or a case more appropriate, the first thing you're going to have to look to is if there's an unequal balance of power between the parties. I'll see in many circumstances, especially high conflict or high net worth cases, that there's a drastic unequal balance. There's usually one party that has either a substantially higher income and a large discrepancy between the two, and or greater access to the finances. So that leaves one party in a position of need where it's more difficult for them to have equal footing in a mediation type of setting. Second, you'll often have sophisticated business interests or investments. The difficult things become more so for the party that is not involved in either the acquisition or maintenance of either the assets or the businesses. So you'll have very complicated valuation questions. You may have significant tax consequences, not only to the terms and the settlement at the exact time, but also future consequences when things are going to be changed or sold. Next, you often have custody issues. So custody issues, one, are very complicated to mediate because of the significance and the difficulty. But often, and again in a high conflict case, you'll find sometimes they simply just can't put aside their own interests or issues and how they see the other party when it comes to custody issues. And sometimes you have no choice but to just request that a judge decide these issues. Often there will be underlying issues of domestic abuse, child abuse, which in part leads to the first part of unequal balance of power. That it is a very common situation where there is an unequal footing between parties. But it also, as we'll discuss this more later, it makes either difficult or impossible to mediate an issue because you clearly have not only personal issues that prevent them, but you'll have legal issues that prevent mediation from helping. So you have sometimes no choice but to go through a litigation process, even if they weren't really looking for that. Now next we're going to take a few minutes and go through a fact pattern, and then we'll use that fact pattern later to see how the issues of the fact pattern relate to the issues that we're discussing. So I'm going to advance here and talk to you a little bit about Harry and Wilma. They are a married couple, and you'll see they were married for 15 years before a request for divorce was issued or requested. At the beginning of their relationship, Wilma was a waitress, and I always go to sing this when I read this part. She was working in a cocktail bar, Her income at the time was about $65,000, but she was making most of that in tips. So while she made estimated between $65,000 and $85,000, the parties only reported $30,000 on joint tax returns. Some of the issues that we'll look to later in this would be the unreported income, the imputation of income possibly to Wilma, and the duration of their marriage are going to be significant issues for us to look at.
Mm-hmm.
Rachel?
Okay, I'm going to take over the fact pattern for a moment. When the parties met until the present, so for the entirety of their marriage, the husband worked as an investment banker on Wall Street at a place called Indigo Stone. His earnings climbed steadily over the years. His annual base salary was about $275, with then up to $750 a year in bonuses and stock options. Issues there might have to do with, particularly if Harry might be the one you're going to be asked to represent or comes to you as a client, he might want to keep a lot of his income, and that's something of importance. It's also, there might be some complicated equitable distribution issues in terms of how he receives his bonus, if there are stock options, what the particular laws are, in terms of how those can be divided and that sort of thing.
And moving deeper into the fact pattern, we see that after 6 years, the parties have twins, Kate and Coco. You can choose which gender you want that to be. Following the birth, Wilma decides to leave her job and become a stay-at-home mom, and takes most of the parenting responsibilities while Harry still continues to work. We also discovered that there's the seedling or beginning of a non-marital relationship that's developing between Harry and a third party. So the issues that we're going to look to, again, is how will Wilma's leaving her job affect alimony and the economic detriment that's created, and obviously the custody issues that begin once they have these young twins.
Mm-hmm. And there's also a note even right there in the paragraph Brad just went over, that with Wilma's focus shifting to really parenting the girls, we're going to start to see that might even be problematic in terms of her parenting and her being maybe overly merged, overly involved with the children, and if that's really healthy for their development. So we're going to have some issues with that too. In May of the 7th year of their marriage, there was an incident in New Jersey. It used to be called DIFUS, but it's basically family services, children and family services. Was called by a neighbor when there was a loud argument at the house that went on for about an hour. And the children were unharmed, but it's something that, the clients might not, or the client might not want to be brought up, made public if it went to court. That might be an issue. Also, that there was evidence of there was this one physical altercation, and I would say in terms of mediation, or some mediators might say if there's ever an instance of domestic violence, or some attorneys might say we can never mediate that. That's a litigation thing. But this happened midway through their marriage. It was an isolated incident, but it left Wilma with red marks on her arms and Harry with a gash on his forehead.
Okay, I'm going to move us a little bit more quickly through the fact pattern just so we can make sure to keep in time for everything. What we see in their 8th year marriage, 2 years after the children, that Harry's relationship with this other person has ballooned and mushroomed into something more substantial. And it is, or will later be discovered, that he is spending approximately $400,000 on different dinners, trips, hotels, and fees for her, which is escort fees. This is going to be significant not only for the dissipation of the marital assets, but that it places a potential risk to his employment and his ability to support his family in the future after this divorce.
Yep, thanks. Harry wants a better relationship with his daughters, partly because of his work and, maybe his extramarital distractions or whatnot. He really hasn't had a substantial opportunity to bond with his daughters. So so he might be at risk of, because there's been this status quo established where he hasn't been the primary parent, that's going to be an issue we're going to want to address. Can there be an opportunity not just for him to continue parenting in the same manner, but maybe have an opportunity to get more involved or to at least address the parenting issues? Also, Harry has some concerns that Wilma is over-involved with the children, and that might be doing them actually more harm than good. Brad?
Okay, next we see a couple years after this and only a few years before they decide to divorce that Wilma enters into business with her sister, who is an established commercial real estate either agent or at least has some sort of business such as that. Harry's not really aware of it or involved in it, but all he knows is that it seems to be producing at least enough income where she's able to buy a substantial asset like a Tesla automobile. The issues that we'll talk about later are aside from the acquisition of assets, but her ability to earn and the value of this business, as well as the difficulty in possibly evaluating it. Turning a little more to the conclusion of our fact pattern, Rachel?
Mm-hmm. Sure. The catalyst for the divorce occurred 3 months ago, so 3 months before Harry comes into your office, when Wilma found out about Harry's extramarital relationship. Her credit card was denied. She called the credit card and found that he'd been carrying a balance that had been unpaid of $75,000. She did some investigating through past bills and saw the pattern of suspect charges and confronted Harry. They're still living in the same house now, but they're in separate bedrooms. And just one issue here is that not only would we maybe worry about confidentiality in terms of Harry and his involvement with an escort service, but also in terms of just his credit. It just brings up to issue how is his credit, and could that even in fact affect his employment with his particular firm if that would possibly compromise him in some way.
Okay, so now we had left the fact pattern with Harry contacting your office and asking whether or not you would recommend mediation or litigation. So, and with that, we're going to have Rachel talk a little bit about what issues are best left for mediation.
Okay, so these few issues, and I think we'll get into them a little bit more deeply when I turn it back over to Brad. Alimony. Alimony is that we do not have, at least I can speak for in New Jersey and in New York, we do not really have black letter law that can say, there's not a calculation that says you will get this definitely, and we can guarantee it if you've been married 15 years, blah, blah, blah. There are many factors. There are a lot of complications, and this is a significant issue that clients often don't feel comfortable leaving up to the court, if somebody's going to decide it who doesn't know either of them or even what's needed. Also, the issue of alimony, not only is it such a gray area, you can have the same fact pattern and get a completely different result in court. We might, in mediation, oftentimes we look at what is needed by both parties. So whereas if this goes to court, it might be, well, Harry's such a huge earner, Wilma gets a third. If in mediation, we might look to what does Wilma really need based on her budget, based on what her lifestyle has been, and we can look at it in a more nuanced way, so there could be the opportunity even for potentially Harry to keep some more than not just looking at what Wilma will be entitled to, which is actually takes me to the last point on the page, so I won't cover that. We have the issues of unreported income. If this went before a court, the judge really has, based on Sheridan, which Brad can speak to more, an obligation to pick up a phone and call the IRS. In mediation, we still are governed by the same rules that govern a settlement conference, which is really total confidentiality in the mediation process, so that, as the mediator, I am not really empowered. I'm not required to disclose anything to the IRS about the just cash income. There's always the risk of the unpredictable outcome in court because there's such discretion left to the judge. and also one great benefit of mediation would be we'd really be able to address the parenting concerns rather than just have a court or anybody else look at the facts and the status quo so far. We might be able to get into some of the issues of Harry really wants an opportunity to be a better or more involved parent, and can we sort of look to that, and also even get into some of his concerns about how Wilma's been parenting, and you know, when I mediate, I try to get into some of their concerns with the clients so that we can have better parenting going forward, so we can use this change as an opportunity to address stuff that hasn't been working and look to how to improve it going forward, and to support one another, you know, to have co-parenting and better relationships with the children, all with the children's best interests in mind. Even though the issues of business valuations and, you know, valuating, there's some complicated assets potentially with Harry's bonus structures and all of that, oftentimes parties would, because the business valuations can be so costly and so taxing, oftentimes parties will want to stipulate to a value of the business, particularly if they're comfortable they have, which may or may not be the case here, some sense of what's really earned, and they might say, look, we're going to call Wilma's early earnings $50,000, you know, but we don't have to document that exactly in the same way that we would maybe need to if we were going through a formal discovery process. And so clients can come probably very close to the numbers they might end up with, spending $50,000 to get professionals or actuaries involved. Sometimes in mediation we don't need to do that, or if we do, if the parties do want to do it, we do it, but instead of having a battle of the experts, they can opt to use and agree beforehand to use one expert and defer to whatever that expert comes up with. Next
now,
slide.
I'm not going to do a similar issues best left to litigation because it's not really that simple of an issue. What I'll try to do throughout our presentation is show you where the issues, for instance, in our fact pattern do suggest that a litigation track is more helpful, because it's never really going to be that clear. And they're going to change from time to time throughout any given case. It will take 1 second just to add to the Sheridan case that Rachel mentioned. What that case says, and it's very problematic whenever there's any kind of cash or underreporting, it says that the moment there's any testimony in court that there's been any underreporting of income, a judge is automatically required to stop the proceedings, notify the IRS, who will most likely then do an audit and freeze all the marital assets. And that's a difficult issue on either side because most of the time both parties are aware that there's some form of underreporting, but neither party wants the repercussions of what's going to happen. So that's usually one issue where even lawyers who say we should litigate this issue won't litigate that issue. It's just too difficult and problematic for the parties. And the courts will usually even do their best to try to avoid bringing this issue in because it just doesn't help anybody involved.
And Brad, if I may, just the privacy issue, if I could just say again, some of these things, by keeping them in a mediation context, we're not going to have any real documentation or any exposure about Harry's you know, involvement with the escort service, his credit issues. All of this has a much more confidential, sort of close to the chest feel than if you're in open court, you know, with some of these issues and the embarrassment it can bring, and the sense of feeling really exposed in a formal proceeding of any kind.
Great. So next we're going to take a second and just launch a brief poll for the listeners. LexisNexis has prepared an extensive ADR manual and publication, and they're interested to see whether or not you would like a copy emailed. So if you could just take a second and just answer the poll on your screen for us. And we're just going to remain for a second, give everybody an opportunity in case there's any kind of technical difficulties getting the responses in or not. It looks like we may have had most of the people that have responded. I'm going to just give it another second or two in case there's anybody that didn't and wants to. It's a very good manual, so I would recommend you that you choose it, but obviously it's your choice, so we'll just give you another minute to tick. All right, so that's probably good. Thank you for letting us know. I assume they will be emailing that to you shortly. Here, I think you can see the results that come up. It looks like 85% are interested in it, 15% weren't. But obviously, that's your choice. So I hope you enjoy the manual. And we're going to jump back into our presentation. I'm going to discuss just briefly a case that has a significant impact both on mediation and litigation for those in New Jersey. I'm not really sure how relevant it may be outside, but it's a relatively new decision that has great impact. And essentially, this decision in the Willingboro Mall case says that if you have a mediated issue or agreement, the agreement must be in writing at or shortly after the mediation process to be considered a binding agreement. If it's not in writing, there's no agreement. So you can spend hours and hours mediating an issue or a case and leave the mediation room because you want to write it up, and then it falls apart. You can no longer enforce that. In the past, you probably could by saying, well, we had an agreement, we complied with it. But now they drew a bright line by saying if it's not in writing and signed, it's not an agreement. And I bring it up only because it's an important point. It's used both as a shield and a sword now. It was created to be a protection so that if you don't have an agreement, there's no question. But a lot of people now go into mediation knowing that if they're not really sure, they can avoid it or avoid responsibility for the decisions or the agreement just by not having a writing. So if you're mediating in New Jersey, I would recommend that you read this case. It could seriously impact the outcome of your case. Now next, I'm also going to take a few minutes and just talk a little bit about the ethics and rules of mediation and litigation. And I'm going to summarize some of the information that you have on your slides because, as you'll see, the specific rules and what we're trying to show you here, the rules don't really differ in mediation or litigation. And usually because, especially in the case we're presenting you today, you have an attorney who's mediating. So your ethics are going to be the same responsibility. Your rules of professional conduct are going to be the same. The issues that are going to be significantly different, for instance, would be the evidence, because in mediation you'll have a much greater flexibility. You're not bound by the rules of evidence, whereas in litigation, obviously, you are. And discovery, similarly, mediation gives you a lot of flexibility, and you're not really bound by any rule other than what you two agreed to, whereas, at least in New Jersey, we have very rigid guidelines for our discovery. There's also other issues that are listed here. Obviously, malpractice is always going to be a concern for either side, whether you're mediating or litigating. It's a little different, I think. I don't know actually the extent of malpractice for mediators. I'm not even sure if that's been recognized yet. But in the attorney litigation standpoint, most litigation cases will still resolve by agreement just somewhere in the process. So the malpractice issues are a little bit more limited as it concludes. We're also obviously going to have conflicts of interest between the process itself and your duties to your client. And then one other topic I'll just touch on briefly that we all have issues and conflicts with is the duty of candor. As we all know, there's duty of candor both to the court, to the adversary, and also to third parties. So the reason why I put this slide into here, and you'll see again, the rules don't necessarily differ, but I think how they get addressed and handled are going to be different. A mediator, again, and Rachel can elaborate if she needs to, is independent and doesn't have any reason to withhold any information or to change any information that's going out to the parties, where when you're litigating and you're representing one party, you have a client to satisfy, but you also have to balance your personal interest of satisfying your clients with your professional responsibility and candor to the court. So there's a fine line between what would be advocacy and what could be candor to the tribunal or a third party. So I think the only one that's a little significant in litigation is the third one down where it says duty to disclose evidence known to be false. I think in mediation that might be more significant because mediation is an attempt, I think, to balance everybody's interest and you want as much open disclosure as possible. I think the duty to disclose, I don't know if it's say false evidence, but contrary evidence or evidence that's contrary to your position is a little lower. Litigation isn't the cooperative process mediation is. It's positional. So I don't think I've ever presented a case that was contrary to my legal position. And I don't think it's actually specifically required, but it is something that we need to keep an eye on, and it's something that you definitely want to consider depending on the nature of your client and your issues as to whether or not you think, as the professional and the attorney, if you foresee either mediation or litigation creating a conflict between these two roles, then that may help you decide whether or not your case needs to go to mediation or to litigation.
Brad, if I can just on a couple of things. The discovery, obviously, or not obviously, but in mediation, we don't have a formal discovery, but we insist on, and I insist in my mediation agreement, there's really sort of an insistence or a reliance on candor from both parties. And, we sometimes examine, look, if somebody's hiding assets, if there's a real suspicion that somebody's hiding significant assets, that wouldn't necessarily be something I would encourage mediation about. If there's a sense that somebody has $2,000 hidden somewhere with their brother or something, I might, we're going to sort of evaluate that may well be true, but even if we got a forensic accountant, if your husband's so great at hiding these $2,000, I'm only talking about $2,000, yes, you don't really trust him, but the cost of kind of sniffing this out is not worth the procedural effort and the expense and everything. So we kind of evaluate that, but there is the presumption of candor, and if I'm give myself kind of the from the forefront, or at the commencement of any mediation, the authority to end a mediation altogether, to terminate mediation if people are not, if I sense or I'm getting, or either party's uncomfortable that the other isn't being fully disclosing. And also in terms of evidence, both evidentiary, and discovery, I'm not following the rules of evidence, so there might be something that somebody really wants to share just as a layperson, as a human being, and it has nothing, it wouldn't be admitted, it's just their sense about things or their feelings, but it's very, very relevant to everything they're asking for, to everything they want, and in mediation, we can hash through some of this. As a mediator also, I'm not looking to really be a fact finder. I'm looking to hear what is really true for one party and what is really true for the other party, and how do we work with these, two interpretations of reality so that we can find some common ground and, and move forward for the benefit of everyone involved.
Yeah, I think to add a little bit to that too, you're going to see often that some issues will change throughout the course, and sometimes it's more appropriate to litigate, and then later you determine it's better to bring it to mediation and vice versa. Like if we turn to our fact pattern, for instance, we know that Harry has an issue about escort services, which would affect his job, and nobody really wants that. So if we may be in the middle of litigation over significant issues and his alimony obligation, but realize that it coming public, what he's been spending his money on could jeopardize his career, we might actually want to deviate and go into the mediation process. So you're going to find, as you're looking at your duty to your client as well as candor to the court, are going to drive issues in and out of mediation, even within the same case. Now we're going to turn to some more specific issues, and we'll see how both the law and the fact pattern we play into part with mediation. So let's first look at custody, which is always a significant issue in mediation and litigation cases. Mm-hmm. So I'm going to first talk a little bit about some of the court rules in New Jersey. We'll probably find that the standards utilized in New Jersey are very comparable to those in outside jurisdictions that might be listening in today. Essentially, the litigation process or litigation track for a custody case is largely, or in part, incorporating a mediation process, but it's different from the mediation process that Rachel's here to talk about. The court in New Jersey will automatically send all cases that are filed for a custody dispute to mediation, but it's a court-sponsored mediation. And I'm sure Rachel will elaborate more on the process, but The process in the courts, it's a very limited process. The time and resources are not going to be significantly dedicated to each individual case because of the volume that they have to deal with. So if or when that is unsuccessful, or if it is unsuccessful, the next process is the court to schedule a hearing. In New Jersey, we call it a plenary hearing, which is a short but a full trial. And that's if the issues, one, have not been resolved by mediation, and two, there must be a genuine and substantial issue of custody or a best interest of the child at issue. It can't just simply be somebody wants to have custody changed because they're unhappy with it. And this is done by an application. So the application, when it's sent to the court has many options of what they're able to do. Customarily, they will or can order custody evaluations, the retention of custody experts. Sometimes there's in-camera or private interviews with the children. And more often than not, because these they can take so long to get the reviews and the expert reports, that they will often enter a pendente lide or temporary custody and parenting time order so that the parties have something to live by during the process. So, and what's important to notice about the litigation track here is that there still is some flexibility like you'll have in the mediation process, because while what I just indicated is what the court has the authority to do, it's not what they're required to do. And the parties can either agree or request for less involvement or less interference. They can agree to a joint expert. They can agree that there will not be an in-camera interview. And for instance, like in our fact pattern, you'll see that there are some custody issues that arise. Harry doesn't have the bond with the children that he would like, and he has a feeling that Wilma's a little overbearing or over-involved. But those don't sound so significant where you need custody evaluations and in-camera interviews with the children. You might just need a family counselor, or you might need to find out what the issue is and a recommendation for its solution. So even though you're in litigation, you'll see with facts like the fact pattern that we showed you today, it doesn't necessarily mean that you have to follow the course that the court's going to lay out for you.
Yeah, I think custody is such an important issue to try to contain within mediation whenever possible, because just like any other issue, the more inflamed things are between the parties, the custody, whether it's really in the children's best interest or not, custody can become a battleground, and a lot of times the parties can get involved in their own anger and their own fears or hostilities or whatnot, and really lose sight of the best interests of the children. As a mediator, working with both parties at the same time, I'm able to hopefully, if the parties have it within them, to kind of keep returning to what does it look like? What do the kids need? Is it best for the kids? There, even the experience of for a child, especially a young child, I would think, to go in and sit with a judge and be interviewed. And I think, there are kind of horror stories where the judge would say, who do you want to live with, mommy or daddy? Judges usually aren't child psychologists. They're judges. And so they don't have the training of how to speak to a child, how to necessarily extract useful information from a child that's going to really be able to go to what's best for the child, what's the child really saying. Well, a young child might want to live with dad because he gets to have ice cream for 3 meals a day, or might want to live with mom because mom's not home a lot and the kid gets to watch TV all the time. So it can also be somewhat traumatic for a child to go have an analysis with a forensic psychologist, for example, and to feel on the spot in a way where they're going to be making a decision that's going to affect who they live with. And that can really put an enormous amount of stress and pressure on a child that can be just traumatic. And the problem with it being traumatic is not that it's one traumatic event, it's that it has an impact on the child that they may carry, he or she may carry with him or herself for many, many years, and it can just affect their development. So you're in this very tender area where typically most parents are likely, and mediation is based on this presumption, they're likely the most equipped to determine if they can be helped to be in a calm state and make these decisions. They're usually the best to determine what is going to be essentially best for their children.
Rachel, do you want to take a second to explain how transitions may affect children and how mediation assists that?
Yeah, I'll just say in some of my recent cases, especially with the downturn of the economy in the last multiple years, which I keep waiting to end, but a lot of people are going through this process and they're still in the same home and they have children. And so in mediation, I'm able to work with the parties about how can we have this workable, because the reality is they need to be in one home, and it can be very tense and stressful. And one of the things that we try to work towards when it can be a possibility is transitioning to a new parenting plan while they're still in the home. And I think it can be really effective because it could be dad's night, and maybe mom was the primary custodial, the primary parent, and dad never really made dinner for the kids before. And I'm sorry if this is sounding sexist, it's just for ease of illustration. If it's dad's night and down the road, dad is going to actually have the kids at his house Wednesday night. But if he gets to, in the family home, try out Wednesday nights are the nights dad's going to have dinner, there can be a familiarity for everybody involved where the kids are still in their comfort zone, dad's still in the kitchen, he knows, and we start to transition the children while they still have certain things in place that can really reinforce safety and family, so that when the parents are in separate homes, there's already a flow set in place. And we can work in this way also to look towards post-divorce, how things are going to look, and to start sometimes trying them out. And so that's one example of how parties transition. Also, mediation isn't just focused on getting the parties their judgment of divorce. It's what is this family going to look like, and how is it going to be as operable as possible post-divorce.
And what I'll add just before we move to our next topic is, while I often support that custody issues are best in mediation to save the impact on the children, when you look at the fact pattern that we have, you see that we have what's referred to in New Jersey as DCP&P, Child Protective Services, and you have domestic violence, which also in New Jersey is or prohibits mediation of issues because of the unequal balance of power. But even if the law didn't say that, I don't know if those are issues that really would be ripe for mediation in our fact pattern, because I don't know if you can say that there is a equal balance of power on these issues or possibly any other issues. Now we're going to move a little more quickly because we want to leave some time for questions. I see some questions are being posted, but we do have a lot of information we want to try to impart to you. So we're going to talk for a second on custody modifications. This is a slide that has some of the law in New Jersey. Again, for those of us who practice here, hopefully this will help you. Essentially, the standard to modify any kind of custody or support or even an alimony is based on a material change of circumstances. Now, one example that's different in New Jersey is if you are paying support through the court system, there are cost of living adjustments which are automatic, but otherwise you're going to be bound by this. It may be similar in other jurisdictions. I'm really not sure. One thing that I noticed when I was reviewing this, again, in our fact pattern, you have a lot of issues that may require modifications in your future. You have young children. Obviously, they're going to grow, and their interests and their needs are going to change. You probably will have Wilma going back to work. She has the real estate business, so her circumstances are going to change, even though currently she seems like an alimony candidate. And you have the imputed income issue because she was a waitress making between 60 and 80, but now she's running a successful business, so that may increase or even decrease. So you may find in the fact pattern that we had modification issues that are going to be, again, litigated or possibly mediated. And Rachel's going to take a second and talk a little bit about modifications of custody also as it relates to mediation.
Yes, and really any modification. What we've had a lot, again, with the economic downturn over the last several years, there are people who've lost their jobs, people who've always worked. This isn't an instance where somebody just leaves their, high-earning job just to spite their because they want to avoid obligations. So when we have changed circumstances, the methodology, at least the methods that we have in New Jersey, you can petition the court for a change in circumstances, let's say for relief for your payments of alimony, and the court, I think, has become more forgiving as it's become so global, kind of the financial crisis. But it used to be that, it would take maybe 6 months until that got reviewed, and the paying party was expected to pay. So the remedies in court can sometimes feel a little draconian, and if parties have in their agreement that they're going to return to mediation, if there's a significant change in circumstances affecting the economics, that's through no fault of no fault of the paying party or no fault of the receiving party, but something's changing significantly. If we can get the parties into mediation, they can often address that issue before it's gone so far that somebody's been without any support for umpteen months and that kind of thing. Some of the things we also see are changes of custody. One of the, a couple years out or a year out, even from a divorce, somebody has an opportunity to move to another state. That brings up a lot of complicated issues. If they don't, in New Jersey, at least if they don't have the consent of the other parent, if it's joint custody, if they don't obtain the consent of the non-moving parent, they can't move. They can go to court and petition, and those laws, keep morphing, and the standards keep kind of changing, even up till very recently. But you have some hefty decisions to be made, and again, is it something to be put in the hands of a judge who doesn't know the child, doesn't know the circumstances? It often isn't to spite anybody. It's just these are the life circumstances, these are the opportunities. In mediation, we can really, in a very specific way, evaluate how is this going to look, how is this going to work, with the idea that it's always in the child's best interest to have a substantial relationship and significant access to both parents. So these are issues that I think we can address in a really nuanced way in mediation.
Okay, and now I think we're going to conclude on the last issue that we have here, because we're running a little short on time. What I have in front of you is the rule in New Jersey that allows for vacating a final judgment. So if there's a need to modify or vacate any issue, whether it be a family matter or a civil matter, this is the rule that you would rely on. I'm going to assume that most jurisdictions have something similar. I'll give you my litigation take on why I think this rule is beneficial and how it helps you litigate versus mediate. The purpose of this rule, as I see it, or the purpose of any rule that limits how and when you can change or vacate a judgment, is it keeps people from trying to do it at their whim. It keeps people from saying, well, there's been a couple years and I think he's making more money, or the children are older, so I think we need to change his visitation or her visitation. It limits litigation by actually litigating these issues because there are standards that need to be met that are much more rigid and almost like a gate to getting into the system, whereas mediation is more of an option. You can, as Rachel said, if you elect mediation in your agreement, you can choose to go back at any time, and sometimes it can be used almost as a coercive measure instead of a cooperative one. Rachel, what's your take on it?
I would say a lot of, I can say at least back to the court-ordered mediation versus clients who self-select and seek a private mediator. They're typically, again, because they're self-selecting, they're usually not parties who are going to use mediation as a coercive measure the same way that I think the court system can be abused, where somebody just keeps dragging somebody, back or motioning or, just to like have them exhaust funds. Mediation is still, you're still paying an attorney for their time. It's still, I think I don't want to say it's cost prohibitive, but people don't really want to go sit down with their ex to hash out issues as a way of tormenting them, and where I think that's easier when it's unilateral. If somebody comes to me as an attorney and it's like, I really want to file this, it's very different than clients who are agreeing and they're going to sit there together with one another. I'm going to be able to, be more involved and just be like, this is not an issue. So I can say in my years of practice, I've not had anybody misuse mediation in that way because it requires so much of the participants to be present and be face-to-face, with the other person. I really don't see it abused in that way. And also, to change custody and to change things with the children, I also see people generally wanting to do what works and not wanting to upset the apple cart for anything that's frivolous or not really having a big impact on the kids, or where they're not really concerned about the children's best interest, or just a big lifestyle change that's, that's necessary.
I'm sorry, I didn't want to cut you off. I thought you were finished. I think now's a good time. We'll take the last few minutes to entertain some questions. There's a question I see here that's probably best suited for Rachel. I'll just read it out real quick. Does mediation contracts require confidentiality by the parties, their attorneys, and the mediator, except when mandated by law, child abuse allegations, future criminal acts, etc.? Mediators required, even in caucus, to keep confidential statements made. Why do you think mediation is not confidential? Rachel?
Okay, so I think this actually maybe goes back to something that, if I'm understanding the question correctly, and unfortunately I can't bring it up on my screen at the moment, I think going back to what Brad said, mediation typically doesn't keep things confidential. I have very, very limited ability to keep things confidential from one party to the other. I aim to have a very transparent dialogue between both of them. There are times when I will caucus, but I will say, at least procedurally, I'd like you to ask the consent of the other party to speak to me kind of offline, and I won't share what you're sharing, but that's a little bit of a slippery slope, and it's tricky. It's something I, continually come back to in my practice. Generally, the confidentiality works between the three of us, and then, of course, their attorneys. But it's nothing, in my agreement, I specifically say my records are not to be subpoenaed. I don't keep original documents. They're not entitled to my notes or anything unless it's a final document that they've signed off, that I've produced for them. So that is really to go to great efforts to keep things confidential and to keep me from ever having to be subpoenaed and then testify, oh, they did agree to this, even if they never signed off on it, or there's evidence that, he was okay with this, or she consented. So it really is a highly confidential thing. I just obviously can't keep confidential between one party or the other, except in a very, very limited extent.
Great, thank you. The next question that I see up here seems to be geared more towards the litigation. It says, with respect to the issue of underreported income by a party, you mentioned the trial judge is required to report the underreporting party. What state law or what law requires a state judge to report it? Well, in New Jersey, obviously, it's the case that we referenced, which is Sheridan versus Sheridan, but that case turned on a judge's ethical duty to report a crime. So I think that while we have a specific case, I think all jurisdictions probably have a similar ethical obligation, just may not have been addressed or codified yet, but I would imagine every judge hearing any crime has a duty to report it, just like if you hear child abuse, it must be reported. Now, going down, we're looking at the next question I see here is, I'll just read it out loud, and then Rachel and I will both try to field this. Unequal balance of power has been discussed as a factor weighing towards litigation rather than mediation. What about a situation in which the power down person cannot afford counsel and the power up person can? A situation statistically likely to favor the power up person in litigation. Rachel, do you want to start that?
Yeah, I'd love to. One of the things as a mediator, when there's an imbalance of power, it's something that's going to need to be addressed, and oftentimes it's not corrected by the court system or by going to court. Oftentimes there's that imbalance of power. We have the potential in mediation. Let's say there's a real financial imbalance, and one of the parties doesn't have the financial sophistication. They haven't had access to the books. They haven't been the earner. In mediation, we can say, you know what, in order to have a good agreement, and in order to have an agreement that's going to stand up, we need to get both of you, we need to bring up the level of sophistication of the less informed party. This party should have access to, and maybe you should pay, the moneyed spouse should pay, or the moneyed spouse might be paying for mediation to begin with. They should pay for the additional services of a financial coach, a business coach, a financial professional who would work with a less financially savvy spouse. So we can address imbalances of power I'm not talking about abuse, but real imbalances of power, imbalances of information, by working with other professionals and resourcing out, to other specialists, and have that in a controlled manner, so that both parties can get what they need to be really brought up to speed to sort of mitigate the imbalance.
Okay, I'm going to try to. I'm sorry.
Yeah, I was just going to say, in litigation, oftentimes, particularly where there's that money issue, there can be almost, it can be an acting out of financial abuse, where the more moneyed spouse can just say, I'm just going to keep hashing out these issues that are non-issues until the other spouse, has no more money, and and it's a little uncertain whether they're going to be able to get attorney fees from the more moneyed spouse and to what extent. So that's another way where they can get taken advantage of, even if they're in the court system.
Okay, I think that's all the time that we have for questions. There may be a way to have them answered separately or at this webinar. I'm actually not sure, but I thank you all for attending, and I thank Rachel for her contributions with us today also.
Yes, thank you all. It was a pleasure to be with you, and thank you, Brad.
And on behalf of LexisNexis, a special thank you to Brad and Rachel for the time and effort that they put into today's webinar. We apologize if your question did not get answered. Please feel free to contact Brad and Rachel using the information you see on the final speaker contact slide. I know they'd be happy to hear from you. Please take a moment to complete the survey that is offered to you at the end of today's webinar. Your feedback is important to Lexis as we continue to put together programs that meet your needs. This is the second in a Day in a Life webinar series. Look for information on our third Day in a Life. Thank you again, and have a great day.